Welcome to the Immigration Lawyers Podcast. I am the host, Attorney John Khosravi, and I practice U.S. immigration law exclusively. For more information about the program, please visit www.immigrationlawyerspodcast.com. Please note that this recording is informational only and does not constitute legal advice. Please consult with a licensed attorney for specific legal guidance that suits your case. Also, this recording is copyrighted and written permission is required for rebroadcasting. For more information about me, please visit www.jqqlaw.com. Hi, everyone. Thank you for joining us on this episode of the Immigration Lawyers Podcast. This is a midweek recap of some changes that happened to the law, in particular the EB5 sector, which finally saw its much talked about and much hyped for the last, 5, 6, 7 year talk of increases and changes to how different requirements for the EB5 MESA program is. So I have one of the best EB5 attorneys, I would say in town, but really in the country, Belma Demirovich Chinchoy, a good friend of mine as well. I definitely have to do an interview to go into her background. I had my first podcast with her. We just talked about EB5, and the second one is just about EB5, but I haven't introduced her to the audience yet. So we'll have a different one where we just talk about your background. But with that said, I just want to jump into it. Thank you, Belma, for coming on the show.
Absolutely. It's my pleasure to be with you, John. Thank you for having me.
Thank you. So what's going on? We finally got news that USCIS releases regulations, much anticipated. Constantly, they kept pushing this forward about, increases in the price, TEA designations. Could you walk us through what happened and what they mean? Because not many practitioners don't do EB5 or even go near it. So what's happening right now?
Yeah, absolutely. Well, John and the listeners, if you don't do EB5, you probably did not even hear about the recent changes and that were formally announced on July 24th. That is when the final rule was published in the Federal Register. But if you are in the EB5 industry, this has pretty much been kind of a ground-shaking magnitude of changes. So since 2017, USCIS has been working to promulgate these new changes and the final regulation on EB5, and they're calling it a EB5 modernization. And it is a rulemaking, so it comes from USCIS. This is not a mistake. This is a change to the law promulgated by the agency, and it has been made final. It's published in the Federal Register. And so there are several very important changes that are taking place. So the first of all, the new rules are effective as of November 21st, 2019. And the rules are going to affect every I-526 petition, that is the investor petition, that is filed on or after November 21, 2019. So anyone who has filed prior to that date will be covered under the current laws, but anyone filing on the 21st or after, regardless of the project that they're filing into, will be subject to the new rules. And there are sort of 5 categories of changes that were announced in this modernization, and a couple of them are really, really relevant to investors, so we'll spend a little bit more time talking about them, but I'll run through all 5 just so that everyone has that on their radar. So first of all, there is an increase in the investment amounts. We no longer will have a $500,000 or $1 million EB5 investment. The investments are going up to $900,000 for the reduced investment and $1.8 million for the standard EB5 investment. Then the second really important rule is that programs or projects rather, so businesses that want to attract EB5 investors will have a much more difficult time qualifying for that reduced investment amount of soon to be $900,000, because USCIS has taken away the ability of individual states to designate project locations as reduced investment areas. So all of decision-making on targeted employment areas or TEAs will go to USCIS. Third rule is that, the third change rather, is that USCIS is clarifying and changing some of the policies related to how H-209 petitions are filed. This is sort of a lesser, of lesser magnitude, a lesser importance to investors. And then finally,
And that's the removal of conditions for the EB5, is that correct?
that is correct. A2-9 petition that's filed to remove the conditions on the EB5 conditional green card. And then the final change is that investors who file the 526 under certain conditions or certain circumstances, they will be able to retain their priority date. This is also a really nice rule for investors. It does not affect a lot of investors, but it is nice to have that, as that's something that EB5 has never had before. And so it is a welcome change. So those are the sort of the main or the broad strokes of what the EB5 modernization regulations are putting in front of us. We can talk a little bit about, sort of the major impact on investors, or if you have any specific questions, Jeanne, we can go into those as well.
Yeah, sure. Just one note is, have they renewed the regional center program, or is that up for grabs too right now?
Yeah, so that is up for grabs, as you say. So this, the changes that we're considering are USCIS rulemaking. They are not congressional reauthorization of the EB5 program. So it's a completely separate procedure, separate process. And so as of today, the EB5 Regional Center Program is still scheduled to sunset on September 30th. So in about 2 months from today. And the Congress has to act in order to extend the program or to make changes to the program if they choose to do that. But as of today, no updates on that. It's still up for reauthorization or an extension on September 30th.
So just for people who don't practice this area, the EB5 program is for investors, and they could do direct investments, start their own businesses. But there's this regional center aspect of it where you could invest in third-party companies that have certain registration with USCIS, and that's the regional centers. And they're allowed to calculate the employment created in a different method than if you're just doing direct investment. And Congress keeps reauthorizing that every 6 months or so with hopes to change it or do something, but they never do. And so the idea was that Congress was eventually going to lift the prices or something. But if they don't reauthorize the regional center program at the end of September, then that November date, which is when USCIS regulations come into play, will actually not be there. So, I mean, if people are in a mad dash to file with the regional center, the first hurdle is trying to get it in before the end of September in case the program isn't reauthorized. And it's probably going to get reauthorized. It's just been what they're doing. But with the government the way it is nowadays, you can't rely on immigration issues being resolved that easily.
Yeah, I mean, that's exactly right. I mean, the EB5 programs since 1992 has this dual track of where investors can pursue a direct EB5 investment, meaning that they can still invest in larger enterprises, but the job creation is direct, and investors have to make an equity investment into the business in question. And then the second track is this regional center program that's considered, by all definitions, really a passive investment, where investors make a qualifying investment that is pooled with generally a larger number of other investors and goes towards financing larger projects. And these projects under the regional center arm of the EB5 program are able to calculate jobs using economic models and methodologies that rely on indirect job creation. So it really takes away some of that burden of, well, did we hire 10 people or did we hire 60 people? Can we show their W-2 wages and all of that? We don't have to do any of that with the regional center program. We simply have to show an economic model that says, for the $150 million that has been invested, in this particular industry and in this particular region, the economic multipliers tell us that X number of jobs have been created. So then when it comes time to proving the job creation, all we have to show to immigration is that the actual $150 million was spent. So it's basically job creation based on expenditures. And these are well-established economic models. I mean, this is not something that's new or specific to EB5. Economic models on job creation, commuting patterns, and expenditures have existed for many, many years, and they're not standard to immigration, but just to the economics in general. But they are used in the regional center program, and there are particular economic models that are used, and so on and so forth. I mean, it gets very detailed and kind of boring to a lot of people when it comes to econ reports. But you are correct. I mean, the discussion I've been having with a lot of clients and a lot of projects is, okay, so what is the potential impact of September 30th? And as you said, the Congress does need to, reauthorize, extend EB5. So most likely, no one's really expecting there to be a permanent reauthorization or a major action from the Congress this year. So the program is expected to simply be extended for another 12 months or a shorter time period. But another element that we have to remember sort of goes into play on September 30th is the budget reauthorization, or budget approval rather. So I'm sure you remember, John, last year we did not have federal government for almost 4 months, and EB5 is folded into that omnibus spending bill. So even if the Congress has all the will to extend the EB5 program, if the budget is not approved, then EB5 isn't going to be a functional program, which is different from pretty much almost every other USCIS service, because USCIS is a fee-based agency. So in theory, they're not affected by a government shutdown because they don't rely on federal dollars to function. But EB5 is put into this omnibus spending bill as part of its reauthorization or extension. So if the budget isn't passed, this omnibus bill doesn't go forward, then EB5 doesn't either. So in reality, I think there is still a potential that something will happen to EB5, that EB5 might go on hold on September 30th if we have a larger, sort of broader government issue.
And is still the vast majority of EB5 investors doing regional center, not direct investment?
Yeah, that is absolutely correct. I mean, especially right now, given the processing times. I don't know if you, I know it's not your area of law, so you probably don't spend too much time looking at what USCIS is doing with EB5, but the processing times have gone up to anywhere from 25 months up to 45 months.
This is for the I-526?
That's correct. That's the initial petition before the investors are allowed to come into the U.S. So, it's causing headaches for everyone, but it's really taking away the direct EB5 as a viable option for most people. Mm-hmm. Because, think of it this way, unless you have another visa to come and stay in the U.S., you really cannot set up your business and let somebody else run it for say up to 45 months and expect that everything is going to go well. I mean, most investors just don't have those kinds of connections to other people in the U.S. So it really, it's really dwindled interest in the direct EB5 as
how often do you even see someone doing how often do you see someone doing an E2 to an EB5? I mean, is this like a unicorn? Technically it's possible, but and it kind of makes sense, each EB5, but do you see people do that actually?
Yeah, I mean, I would say I have a lot of interest. I have a lot of conversations with clients about that, and about 50% of the ones that I speak with end up doing it. And the key reason why 100% don't do it is because they decide that really their business may not it might not be optimal for their business to have 10 or more jobs.
Yeah.
In other ways, a lot of the E2 businesses are, very successful, but they don't necessarily need more than 5 or 6 employees. And so putting that burden of creating 10 plus jobs onto the business may really have a negative business effect on it. So that's a conversation I always have with my clients. Is like, look, we can absolutely do this. It works perfectly fine as long as you think this is a good thing for your business. And that's where like about half the people walk away and say, look, listen, I want to run my business as a business. I don't want to have the extra pressure of having to create these jobs and having to hire W-2 as opposed to contract workers, or sometimes you just want to outsource, but EB5 doesn't allow you that. So EB5 does place some pretty significant restrictions on the businesses, and so then clients decide to keep their E2 business as an E2 business while they pursue a regional center EB5, which then just gives them the freedom to run their business more in line with the business needs as opposed to immigration rules.
And those that did direct investment, they're thinking E2 to EB5 with the price increase now. If they don't file the I-526 in time, it's going to be a headache. They have to gather all this extra money to dump into the business.
It really is. I mean, that's we are expecting to see a chilling effect on investors. One of the things I wanted to spend a little bit of time on is this sort of the idea that we still have the reduced investment amount of $900,000 under the new rules. And a lot of people in the industry are saying, well, it should be fine. We're going to have a bit of a cool down period, but the industry will recover, within 6 months or so. But what we're also understanding is that it's going to be extremely difficult to qualify for the reduced investment amount. Today, to give you an example, a lot of the states, well, first of all, the states are tasked with issuing TEA or reduced investment amount certifications. So a business would, say you want to locate a business in South LA, you would go to the Secretary of State of California and you would file a request to have your specific business location designated as a reduced investment amount. For a place in California, I would say the average unemployment, well, we know that national unemployment is about 4.2% or 4.3%. So in order to qualify for reduced investment amount, we have to show that the unemployment is 150% of the national level. So anything about 6.5% unemployment and up would qualify. It's pretty hard to find areas in Metro LA that have unemployment of 6.5%, but there definitely are some areas. But what the law in California tells us is that we can file a request with the Secretary of State, and we can join up to 12 areas based on the address to qualify. So say, for example, your business is located in say West LA, where unemployment is probably 2% or something like that. But we know that, say like far parts of East LA or even far parts of Long Beach area, they have pretty high unemployment in some of those areas, including South Central, etc. So you could literally like take your location and then grow the geographic sphere of your location using the census tracts to link up to 12 census tracts and create an average unemployment that qualifies. So that's how we see projects that are, even in Beverly Hills qualifying for targeted employment area. And that's really the same in New York, in Florida, and so on and so forth, which is why most of the EB5 projects are located in these major metropolitan areas and states that see a lot of investment. And USCIS is really trying to fight that. They believe that this was not the congressional intent, that we really want to see investment dollars go into parts of our country that don't see the investments pour in. So they're really taking that, the decision making on the TEA, they're taking that back. And under the current rules, it's going to be very difficult for projects to qualify unless they truly are in a rural area or they really are in an economically depressed area, and then USCIS would still grant them that reduced investment. We'll see how that's going to shake out, but most people think that there will not be any reduced investment opportunities because developers aren't keen on putting their own dollars into areas that are truly economically depressed. So effectively what that means then is that we're going to have EB5 investment amount be 1.8 million, which I think will really have a chilling effect on the project.
Like from your clients, do you think if the amount was that much when they first came to you, is that something that's viable for them, or they have the willingness, or is that a different strata of millionaire that would be willing to do something like that?
I mean, I would say, just sort of like off the top of my head, I would say maybe about 40 to 45% of my clients could make that such an investment. You know, for a lot of EB5 investors are, you know, high net worth individuals, but you know, many are also individuals that are putting their savings into this project and really using it as their, you know, it's their family's insurance policy. They're, you know, they're really putting in their life's earnings towards getting green cards for the family so that the kids can, you know, come and live in the US, you know, and sometimes even the grown-ups, you know, the parents would not even come to the US. So, I mean, I would say that at least half of the clients would not be able to digest a $1.8 million investment, but maybe it's even more than that.
And I mean, you don't have to get too much in detail, but do you think these changes are going to have an effect on the legal fees that attorneys are going to charge the clients? Is there significant enough changes, or, I mean, you got to read 200 pages and make that attach, and you know the government's going to come after them more, so that's more legal hours. Is there going to be an effect on legal fees in this area?
You know, I really don't think there would be a great effect on legal fees because we don't, you know, the investment amount is the investment amount. There's really not much for attorneys to do there. The TA designations, it doesn't seem like we're going to have any ability to advocate on what those are and how USCIS should change their rule. But although I'm sure this is an area where we might see some litigation, you know, potentially there is a way to pursue you know, to file a suit against USCIS on how they make TA designations and see how that, you know, that might have an effect. In terms of, you know, USCIS removing conditions, you know, one thing that was announced with the filing of the Form I-829 removal of conditions is that individual dependents are allowed to file separate 829 petitions from the principal. And in some cases, those are going to be required when individuals don't, when one family doesn't all immigrate at the same time.
Mm-hmm.
So if you think about it this way, like, you know, if a father comes first, but then the spouse and the two kids, for example, they come in, you know, 18 months later, the removal of conditions is going to fall on different times, essentially, because the conditional period is 2 years, and at the end of the conditional period is when the H-29 is filed. So we would just file for everybody at the same time under the current rules, but I think now we're going to see more opportunities for separate filings, and so immigration lawyers might see additional filings created there. So not necessarily additional fees on what we're doing, but maybe more filings than in the past. Also, I think a lot of, because there's now priority date retention, for those investors whose projects have either stalled or failed, they would be more inclined, or they might be more inclined to file a new I-526 petition and try to get out of the current project. So that's another area where immigration attorneys might see a little bit of additional work. Again, not necessarily higher fees on what we do, but maybe additional filings.
That's an excellent thing they did for that, because there's so many regional centers that stalled or there was fraud involved and these people are stuck, and it's a horrible situation to be in. Right. I mean, you and I get calls about people in Chicago all the time.
Yes,
that situation.
Yes, exactly. That is very true. But you know, the only thing there is that, you know, if the investors are able to get their money out, which in a lot of times they're just not. When these regional centers fail, if they fail for fraud, that generally means the funds are not there to be returned to the investors.
So they would have to bring new money, but they would still be able to keep the priority at the very least. So there's some
That's
saving grace.
correct. Exactly. Exactly.
Oh man, very interesting. So I mean, the prices are a game changer in this area of law.
Hmm.
Maybe in a couple of years, we'll see the backlogs go down, the visa bulletin kind of calm down. Maybe it'll still be a couple of years before that happens because there's enough backlog in the system that's throwing things off.
Well, are you doing a special session on the SB 1044?
Oh well, I was talking to Ira Kurzban about that, and it's such a controversial thing. I'm trying to connect with actually Senator Rand Paul's office and the various senators that are involved in this, and it's just hard to
Okay.
get a hold of and talk about it. But I mean, the name calling is pretty nasty. With people calling each other racist and stuff like that. It's just so
Yeah,
bad.
it's really bad. But that's, that's like something. I mean, I know it's very controversial, and to be honest with you, I haven't really reached out to congressional reps to talk more about this. I still think it's kind of out there, and I don't know that it has a great chance of success. But talking about the visa bulletin, like you just mentioned, if if we remove the per country cap, then that's going to have a very detrimental effect on EB5 because
Yeah.
right now we have three countries that are backlogged. China is severely backlogged, and Vietnam and India are somewhat backlogged. But still very much tolerable kinds of backlogs. If we remove per country cap, then it's going to help the Chinese investors. They're probably going to see their backlog shrink by a third, or if not more. But everyone else in the world is going to have an EB5 backlog. So we're going to have, basically like 97% of the world that currently does not have an EB5 backlog would end up experiencing backlog. And so it would have a very much, again, chilling effect on the program if it happens.
Yeah, and I appreciate the difficulties those families go through, but it's just gonna like I do EB1As, and that category is already backlogged. That's gonna
Yeah,
decimate it, and like a lot of talent's gonna be left on outside, and
yeah,
it's so weird
for
that these
sure.
delays happen on these employment-based cases. Now, investors they could wait, but like in EB2 and EB3, if you're gonna be hired and it's gonna take 10 years for you to come, it
10
doesn't even
years
make
for
any
you to come
sense.
and work. Yeah,
Yeah.
no business can sustain that.
So, I mean, yeah, it's a mess. I mean, they got to increase the numbers, but that's kind of controversial. Or change the way they calculate derivatives. I think that's the most palatable is stop for EB5. It particularly stop counting the family members. And Ira
Right.
Kurzban saying he's suing on that in the EB5 context. But who knows if that's going to happen? But I do feel for these Indian people. They're Ira put a good way. Indentured servants. It was someone else I talked to actually, a Congress behind the scenes Congress person. They're indentured servants in these H-1B categories. They're stuck here. And
Yeah.
I think the tech companies are really pushing this, and that's their thing. That's why Congresswoman Zoe Lofgren from her district did it. But
Mhm.
I'm not sure if this is really it. But right now, they have these Chinese and Indian workers with these huge backlogs, and they control them. And so, yeah, they're throwing a bone there by like bringing the time down low. But what happens is their only H-1B employees aren't Indians. There's other countries and they
Mhm.
were able to get their green cards faster. But in a backhanded way, that's kind of screwing them because now they could turn them into indentured service until the green card's
Right.
ready. And so they could dangle that green card in front of them and control them. So it's actually going to hurt wider swaths of people as well. But I know these Indian people who have Indian clients, a lot of times they get married in the midst, and I do their cases because I don't do perm. But it sucks, man, being stuck with the company, not be able to leave. Sometimes they're stuck with one company. They live in LA. The spouse is in New York, Washington, D.C.
Yeah.
They got to be separate. And it's just like, what kind of life is that?
No,
Uh,
it's
yeah.
definitely not sustainable. I mean, and I think for, it really inhibits the economy in many ways. Like you're saying, being stuck in working for a particular company, that's really not ideal for a market-based economy. We want to have labor mobility. We want to have, sort of there's just so many parts that shouldn't be tied, many parts about our economy that should not be tied to immigration.
Hmm.
But this is a system we have right now.
Yeah, fixing it. I mean, other than increasing numbers, which is like it's right now under Trump, just keeping the numbers as it is the fight. I don't know what's going to happen. And family based has the same kind of issues. Countries have 25-year backlogs. The Philippines, there's some crazy numbers.
Yeah,
Uh,
those are not
yeah.
reasonable at all. I mean, that might as well not have the category whatsoever.
Yeah, exactly. So I would say just find a U.S. citizen and marry them and fall in love and bona fide, but just fall in love and get married. That's the way to solve this kind of stuff. The F2A category surprisingly became current. So these kind of weird stuff do happen.
Right, right, right.
Belma, you've also started your own firm. Congratulations. If people wanted to reach out for you, do you have a new email address, a new website, or are you keeping
Right,
the old
that's
email
right.
address?
Well, I mean, I wouldn't say I started my own firm. I've had my own firm since 2015 or 14, I think. But I have formed a partnership with two other extraordinary immigration attorneys, and we do have our our brand name is Immigration General Counsel, as that's what we really like to think of ourselves as being the general counsel to a lot of our clients when it
Mhm.
comes to immigration matters. And we'll have a couple of offices here in the LA metro area. I will primarily be handling the investment side of cases, again, E2s, the EB5s and L1s, and my partners are handling all of the other corporate matters, and focusing on the healthcare and physicians and pretty much any kind of a corporate matter that involves H-1B and perms, but a strong emphasis on healthcare and physicians, as well as esports.
Oh, ones in particular in that area. Yeah.
L1s and O's, exactly.
Wonderful. And I've had an interview with Jeanne Doyle, one of your partners, a couple of episodes back, and she was wonderful. And she just did a wonderful lawsuit on behalf of one of her clients for, I
You
think it was a
did.
P3. So I'd take some courage, really stick it to them and say, you guys are doing some crazy stuff. Yeah.
Well, it's a very well filed lawsuit, I would say, because the decision was absolutely not supported by facts or the law, and I'm really proud of Jean's client for being willing to take the risk.
Mhm.
And it's obviously it takes more time, it takes additional resources to do it, but I think they're doing what's right. And I think ultimately all of us have to do that in order to push back, because immigration is really not playing by the rules today. So
Mhm.
we have to, somebody's got to sort of keep them on task and bring him to court.
Yeah, that's the way it goes. And that's just the law. That's nothing personal. Just sometimes you got to do
Absolutely. No, it's
that.
not personal at all. It's like, this is the law, these are the facts, your decision is wrong.
Yeah,
Judge,
of course.
please fix it.
So if you want to reach out, what's the best email and website, any social media if you use social media?
Sure. Our website is immigrationgc.com. And my email is Belma, that's B as in boy, ELMA, at immigrationgc.com. Our website will have all the links to social media, and but we're just transitioning to the website and all of the other channels, so it's still a limited today, but it should blossom in the next few weeks.
Awesome. And immigration GC sounds like immigration green card too. So is that a little bit of dual? Was that intentional or
There
just
you
worked out
go.
that
That's great.
way? Wonderful. Thank you, Belma, for coming on the show. I look forward to talking with you again and having a full interview about your background. And you've had a very interesting background yourself and how you came to be an immigration lawyer.
Thanks, John. Yeah, I'm always happy to chat, reach out, and thanks for doing this. I think it's really it's a neglected part of our immigration program, EB5, but it's a really great program, and I hope more attorneys take interest in it. And there is definitely great opportunities for investors that are looking for a somewhat reasonable way of getting that green card.
Wonderful. Thank you so much.
All
Have a good
right.
one.
Take care. You too. Bye bye.
Bye bye.